Yeah.
Thank you so much for enlightening us with your presence. It's a great pride for us to have you here. So, how was your experience with the crowd? How did you
Right.
like the lecture?
No, I thought it was a very lively audience, and I thought the questions were of a very good quality. They were very good quality, and I'm glad I could see that the students were thinking about what I had said and
Right.
sort of thinking what were the challenges of the work that we were doing. I was thoroughly impressed with the quality of questions and interaction. Yeah.
Right. So, now how did you like the faculty, the students, and
Yeah.
the university overall, the
Yeah.
infrastructure?
Oh, it's stunning. I was, I don't think I was quite prepared for this. Just the kind of facilities and the infrastructure and the quality of faculty, the number of young faculty. I think all of this put together and the leadership of Professor Bharti, I think all of it together bodes very well for the law school. And yeah, as I said, I must admit, I wasn't expecting all of this to come together like this when
Right.
I agreed to come. But going back, very, very hopeful and very excited to see where Manipal's law school in Jaipur goes. Yeah, I think lots of things going for it together. Yeah.
Thank you so much, sir.
Yeah.
So, delving into the legal aspects of Project 39A, it has extensively engaged with the issue of fairness in the administration of the death penalty. How do you see the evolution of the fairness doctrine in death penalty jurisprudence in India, particularly from Bachan Singh to the recent Supreme Court cases?
Yeah, so I think it has always been a tough issue on saying how much of fairness is enough fairness, right? Or is there any such thing as too much fairness? So when the court upheld the death penalty in Bachan Singh in May 1980, it was clear that it was upholding it on the basis that it will be administered along certain parameters, and those parameters will be applied consistently. Unfortunately, in the nearly 45 years since Bachan Singh, that the courts haven't managed to achieve that consistency on what is the procedure we will adopt to sentence people to death, right? Even the basic things like, when you're looking at deciding whether to give death or not, you will look both at the seriousness of the offense, and you'll also look at circumstances of the accused person.
Right.
Now, the court has never clarified in nearly 45 years who is going to collect these materials about the accused person's life. And they're all extremely poor, as most people on death row are. So nobody's going and meeting them and collecting all this. So the law has said we need this information, but it hasn't clarified about how we will get these for these poor people to come into court. Because of that, much of death penalty sentencing has been crime focused. Whereas the law is that it can't be crime focused, it has to be crime and circumstances of the accused. Unfortunately, the second part we have struggled to bring in,
Right.
and that has been a serious problem with the fairness of the death penalty. Yeah.
So, how do you think that Indian courts could implement all the aspects that were
Yeah.
laid down in Bachan Singh?
So the Supreme Court in the last few years, I must say that, starting with Justice UU Lalit's bench, and then the bench headed by Justice Gawai, and then now by Vikram Nath, it has tried to streamline some of these processes, saying that there must be a report from the prison, independent psychiatrist, the defense themselves must submit a mitigation investigation report. They have tried to streamline this process and make it clear that these are the things that must be brought before us. Uh, but unfortunately, that effort of the Supreme Court has not percolated to the high courts and the trial courts. So even to this day, even though the Supreme Court said this in 2022, it has been trying since 2022. Very few trial courts and high courts are following what the Supreme Court has said. Now that is a grave area for concern. That when sentencing somebody to the harshest punishment, the courts, the high courts, and the Supreme in the trial courts are not following what the Supreme Court itself has laid down. So that I would think is a big concern. Yeah.
So, if you could define what rarest of the rare
Yeah.
cases can be, because we do not have anything
Yeah.
as such in our
Yeah.
statutes.
Unfortunately, I can't, and I don't think anybody can, and that's really the problem about rarest of rare. It can mean so many different things to different people. So, Project 39A did a study with 60 former judges of the Supreme Court called Matters of Judgment. We interviewed 60 former judges of the Supreme Court, and one of the things that we were asking them was, what do you understand by rarest of rare? It is so amazing that the numerous meanings of rarest of rare that emerged. And that is the problem. It doesn't represent any standard at all. It is like this empty vessel, and you can put whatever you want.
Right.
into it, and each judge is calling rarest to the rare something, right? But the thing to focus on is that the Supreme Court in Bachan Singh, when it said rarest of rare, we often misunderstand it to mean rare crime. Is it a rare crime? That is not what the meaning of the phrase rarest of rare is in Bachan Singh. Bachan Singh said you follow a certain procedure, you look at aggravating circumstances, you look at mitigating circumstances, then you see if the accused is, there is no probability of reformation, right? Has the state argued that there is no probability of reformation? And is the alternative punishment of life imprisonment unquestionably foreclosed? So there are some steps laid out in Bachan Singh that you have to follow. And once you follow those steps, the court said you must impose the death sentence in the rarest of rare cases, which is in as few cases as possible, which is the meaning which the court intended. But over the last 4.5 decades, it has taken on the meaning that, oh, you just have to say, is the crime rare? That is not what is the meaning. Unfortunately, it has broadly taken on that meaning. But more broadly, as you started, what is the meaning of rarest of rare? I wish anybody in this country could tell you what it is, and the tragedy is nobody can.
Right. Thank you so much, sir. Sir, the reports note that the only 12% of those facing criminal prosecution avail legal aid, and despite the fact that 75% of them are below poverty line.
Yeah.
How can the legal community and institutions like Project 39A work towards the improvement of these legal representation?
Yeah, no, it's a shocking figure on the usage of death on the usage of legal aid, right? As per the paper that I have published with Gail Andrew in the Indian Law Review,
Yes.
as per the government's own statistics, only about 7% of the people eligible for free legal aid use legal aid, right? And in a situation, as you rightly pointed out, where a large proportion of incarcerated persons are poor, why aren't poor people using free legal aid?
Right.
And why is the usage of free legal aid so low? It is a damning indictment of our system that people don't have the confidence to go to legal aid lawyers. And we really need to ask, why are people not, the poor people of this country who can't afford it, why are they still taking on debts and engaging a private lawyer instead of going to the free legal aid lawyer? Because there's no confidence in the system, and that is because of the various things happening in the legal aid system. That is why they're not going to legal aid. But nobody seems to want to ask these tough questions. Yeah.
Right. So, and what about the reports that highlight the role of social work fellows
Yeah.
in bridging the gap between under-trial prisoners and the legal representation?
Yeah.
How does the integration of social work into the legal aid enhance the quality of representation?
Right. Very good question. I'm so glad you asked it and that you read the report so closely. Right. Very often when we imagine legal aid and the way the state legal aid is imagined, it's like, we just have to give a lawyer.
Right.
But there is so much about the experience of incarceration on when you apply for bail. Is the other people in your at your home who's willing to accept you? Are they willing to post bail? Right. Various concerns that incarcerated persons have in prison around their mental health, around their physical well-being. Are they adjusting properly? So if you're providing assistance, it can't be just I will provide you one lawyer in court to make your arguments. There are a lot of other aspects of an incarcerated person's life that are relevant to his liberty, his or her liberty, getting out, adjusting in prison, that requires a social worker. A lawyer is not trained to understand these experiences and get people to talk about these experiences and do something about it. You need social workers, and the idea in our fair trial program has been that the imagination of legal aid is not just one of lawyers, it is also of social workers who can then provide broader assistance to incarcerated persons, and we're not just talking about arguments in court.
Right. So, do you suggest that lawyers should work with social workers hand in hand to aid for all these people?
Yeah, I mean, a legal aid system has to have social workers. This is the point we are trying to demonstrate through our work in the fair trial program in Pune and Nagpur, that an effective legal aid system will also have social workers providing their services to incarcerated persons. Otherwise, it's not a wholesome support that is given. If you just say, okay, this is just about making arguments in court, that lawyer doesn't even talk to the accused person, because the way criminal law is generally practiced, they just need the papers, the file, and their arguments are made on the basis of the file. They don't need to talk to the accused person at all. But it is a very dehumanizing experience for the incarcerated person if the person who are supposed to be helping them are not even talking to them. Right?
So, do you think that all these things that are going on in an accused's life is affecting his mental health so griefly?
Absolutely. It's the idea that I don't know what is happening in court. When is my next court date? Has my bail application been filed? Has bail been granted? If bail has been granted, can I meet the conditions of my bail? Once I post the bail, where am I going to go? All of this is already, prison is a very anxiety inducing space, right? And every small experience of, example, for the first time, how you're taken in the bus from the court to custody, how you're treated in that bus, the first, sort of first day in prison where you are stripped and searched, and spending the first, so every little thing, you can only, I mean, we can only talk about it and imagine it, right? But you can imagine what is the experience of that person. So prison as such is a trauma and anxiety inducing space. In addition to that, then not knowing what is happening with your case, how long will I be here, is it 2 months, is it 3 months, when will I get bail, can I apply for bail, all of that only further adds to that trauma and anxiety. So I would think there's a very close relationship between access to justice and the mental health of incarcerated persons. Yeah.
So, according to the provisions of BNSS recently, the accused also has the right, as well as the victim also has the right to get the charge sheet and all the materials that the court has.
Yeah.
So, what do you think about that?
So, I mean, I think it is codifying what is has come up in the law, but the real question is, what do you do with it?
Yes.
Right? What does the victim do with it? Right? How good is assistance to victims? How effective is assistance to victims? What are the exact contours of assistance to victims? So, even if I, as the accused, get my charge sheet, can I make arguments on charge? Has somebody explaining to me that, oh, there is now framing of charges? You got the charge sheet, now we will argue on frame. What can you argue in framing of charges?
Right.
Very often, what I have found through my research and my experience through all these last 12 years is that it is such a black hole for the incarcerated person, right? They don't know what is in it, how to find their way out of it. And I think there's tremendous service to be done, even if we don't fight their case or do anything, just being there and explaining to them what is happening will, I think, be of tremendous assistance, right? But we are not even able to provide that basic level of services. And I think that's where institutions like law schools need to step in. The state is not going to be able to do all of this. It cannot, it will not, it is not a priority. And that is why institutions like law schools need to step up and fill some of these gaps.
Yeah. Right. Thank you, sir. So, despite the availability of state-sponsored legal aid, the report indicates a significant underutilization by undertrial prisoners. What are the primary barriers preventing prisoners from accessing legal aid?
See, as I said, the paper that I've published with K. Landgrove in the Indian Law Review shows that there is underutilization. The truth of the matter is nobody really knows why. When I say nobody knows why, there is no credible research that has been done to establish why. There are many reasons we could speculate as to why it is happening, that there is such severe underutilization of legal aid. But again, as I said, there is no systematic research, academic research has been done to establish this. So in the realm of speculation from experience, from what one has seen, one is that there is a great crisis of confidence in the legal aid system, right? So I don't think it is a problem that people don't know that legal aid is available. I think people know in prison legal aid is available free from the state, but I think the problem is nobody wants to use it, right? And they don't want to use it because largely in the prisons the narrative is do whatever you can to get private legal representation because legal aid is terrible, quality is not good, people are not, the legal aid lawyers don't provide good quality legal assistance, there is corruption. Even though you're not supposed to be charged for any money, they will say, oh, if you want documents, pay me this much. If you want me to file your bail application fast, you pay me this much. So anyway, there is corruption and there's a lot of situations where the legal aid matter that goes to a lawyer is converted into a private wakalat. So there are lots of concerns about the quality and the integrity of the legal aid services that are being provided. And on the other hand, it's also not responsive. Nobody is telling these individuals who are incarcerated when is their case coming up, what is happening, what is the progress. All of that is problematic. So I think it is a service in which even the poorest person has no confidence. And if they have an option, they are going for a private. That doesn't mean they're getting proper legal representation, but they'd rather go for private lawyers. And you shouldn't be surprised, right? If it's the same for so many other state provided services. If people had a choice, they wouldn't send their children to government schools. If people had a choice, they wouldn't go to government hospitals. Right? So similarly, if you have a choice, then the narrative in the prisons is that don't go for state legal aid.
So what do you think about the lack of awareness?
I don't think that is a problem.
Okay.
Right? I mean, actually, again, as I said, there is no research to establish if 100 under trials in the prison, how many of them know that they can access free legal aid? I don't know. There's no research for that. But at least, as I said, I'm speculating here. I would say with reasonably well-informed speculation that I don't think awareness is the problem, that people don't know that legal aid is available. I think people know, but they're like, if there is any way I can get private legal aid, private representation, I should get private representation.
They prefer private.
Yeah. And you will see that difference between the trial court, high court and the Supreme Court.
Right.
As the cases go from the trial court to the high court and the Supreme Court, the dependence on legal aid increases. At the bottom level, people are really trying to get private legal aid. And then it gets farther away. It is in the state capital. People don't have access. They can't go that far. They don't have access to lawyers, networks. So then they start depending more on legal aid. In the Supreme Court, it's even more difficult for them to access private lawyers in the Supreme Court. So you can see the dynamic that the reliance on legal aid increases as you go higher in the appellate process. Yeah.